This is the last discussion under the subject criminal justice system. In the previous set of discussions, we tackled about the first, second, and the third pillars of the criminal justice system, specifically the law enforcement pillar, the prosecution pillar, and the court pillar. So today, our discussion will mainly focus on the last two pillars of the CJS, specifically the correction pillar and the community pillar. So let us start first with the correction pillar. So correction is the branch of administration of criminal justice system charged with the responsibility for the custody, supervision, and rehabilitation of convicted offenders. It is also defined as the study of jail or prison management and administration, as well as the rehabilitation and reformation of criminals. So the first contact of the criminal or the perpetrator of the crime is the law enforcement pillar. So dito siya gi-arrest. Okay? Dito siya i-dakpon or i-put into custody. And once there is a complaint filed against the perpetrator or against the suspect, the complaint shall be channeled to the prosecution pillar. So the prosecution will be the one to determine whether there is a probable cause to hold a person for trial. And if there is a probable cause to hold a person for trial, the prosecution pillar will issue what we call as the information. So based on the previous discussion that we had, information is the written accusation which is furnished by the prosecutor. So if there is information, that information shall be submitted now to the third pillar, which is the court. On the other hand, the court has the responsibility upon receiving the information. It has the responsibility to check, to determine whether there is really a probable cause to hold a person for trial. So based on the discussion that I made last time, there are two pillars of the CGS which is mainly in charge in the determination of probable cause to hold a person for trial. Number one is the prosecution, and number two is the court. So the judge will recheck again, reinvestigate, scrutinize whether there is really a probable cause to hold a person for trial. And if there is, what will happen is the judge will issue the so-called warrant of arrest. The warrant of arrest is an order which is directed to a peace officer commanding him to arrest the person stated or mentioned in the warrant. But if in case the person to be arrested is already in custody, the judge will not issue a warrant of arrest but rather issue the so-called commitment order. So if the person is already in custody, trial will begin. And during the trial, if in case the person or the suspect is found to be guilty beyond reasonable doubt of the accusation charged against him, what will happen is the person given with the verdict of being guilty shall be transported for rehabilitation purposes to the fourth pillar of the criminal justice system, which is now the correction. So correction, its responsibility is on the rehabilitation of offenders. So when we say rehabilitation of offenders, this mainly changing the behavior of a person from being a law violator into a law-abiding citizen of the community. Jail administration and control in our country is distributed to at least 4 agencies. So this is now the fragmented structure of the correction pillar in the Philippines, because those agencies or institutions which handles on the rehabilitation of offenders belongs to various supervisory institutions. Like say for example, in the case of Bucor or Bureau of Corrections, Bucor is under the Department of Justice. Its jurisdiction is on national prisoners. It has supervision over the National Penitentiary and its penal farms. For example, Bilibid Prison, Iwahig Penal Colony, Davao Penal Colony. These are penal institutions that are under the BUCOR, or under the Bureau of Correction. Bureau of Correction, on the other hand, its supervisory agency is the Department of Justice. At the other side, we have the BJMP, or the Bureau of Jail Management and Penology. BJMP is under the Department of Interior and Local Government. So as I have said a while ago, fragmented ang structure. Nga naman, ang BUCOR is under sa Department of Justice. Ang PJMP, on the other hand, belongs to the Department of Interior and Local Government. And DOJ and DILG are two different departments of the government. It has exclusive control over all city, municipal, and district jails nationwide. So, ang nakalahian is BUCOR supervises on national penitentiary and penal farms, while Bureau of Jail Management and Penology, or BJMP, handles or control over all city, municipal, and district jails in the Philippines. On the other hand, we have the provincial governments, which is under the Department of Interior and Local Government. The provincial governments supervise and control the respective provincial and sub-provincial jails. So let us say, for example, the provincial rehabilitation and detention center in Dumaguete City, since that is classified as a provincial jail, such institution belongs to the provincial government. On the other hand, the Department of Social Welfare and Development takes care of, among others, youthful offenders entered in detention centers for juveniles. So, youth rehabilitation centers are actually under the supervision of the PSWD. On the other hand, the Parole and Probation Administration, which handles or supervises parolees and probationers, as well as the BPP, or the Board of Pardons and Parole, are two agencies under the Department of Justice. So there are three primary schools of penology. One is the classical school, the second one is neoclassical school, and the last one is the positivist or Italian school. So unsa may nakalahi aning tulo? Ang classical school, it viewed human beings as individuals having rationality or having the so-called free will. So it has the assumptions that all individuals can calculate pain and pleasure. So in this school, punishment does not exempt irrespective of whatever background of a person. Bahala nagbata, tigulang, bahala nag-suffering from insanity or psychological disorders. Under classical school, if a person will commit a crime, considering that na free will or rationality, kana nga tawhan na dapat i-punish under the classical theory. But in the neoclassical school, it gives some oppositions on the theories of classical school. Because in neoclassical school, naay gamay nga changes. According to the neoclassical school, since children and lunatics and those persons suffering from psychological disorders cannot calculate pain and pleasure. So therefore, these individuals should be exempted from punishment. So muna nakalay sa classical o neoclassical. On the other hand, in the positivist or Italian school, it adheres that crimes, as any other acts, is a natural phenomenon. Criminals are considered as sick individuals who need to be treated by treatment programs rather than the punitive actions against them. So in the Italian or positivist school, it views crimes as a product of internal and external factors that are beyond the control of man. So it assumed that criminals are sick individuals. When they say sick individuals, ang sickness na gi-refer ani is ang behavior or ang personality sa person. So if a person has bad personality, according to the positivist school, considered siya sick individuals who needs to be hospitalized. So unsa may buti pasabot sa hospitalization? The word hospital under positivist or Italian school refers to penal institutions or jail institutions whose task is to rehabilitate persons or rehabilitate those individuals who are considered to have criminal behaviors. So again, ang classical school wala ga exempt og
person in terms of punishment. Neoclassical school, it exempts children, lunatics, those persons suffering from psychological disorder from punishment. And positivist school, on the other hand, assumes that criminals are like sick persons who needs to be hospitalized. Now, let us go now to the justifications of punishment. So, the first justification of punishment is what we call as retribution. So, nga namang naay punishment, o nga namang kinahanglan nga i-penalize ang usa ka tawo nga nakakumit og krimen. So, usa sa mga justification ani is kaning ginatawag og retribution. So, retribution, the punishment should be provided by the state whose sanction is violated to afford the society or the individual the opportunity of imposing upon the offender suitable punishment as might be enforced. Offenders should be punished because they deserved it. So that is one of the justifications. The second justification is expiation or atonement. It is punishment in the form of group vengeance, where the purpose is to appease the offended public or the group. The third justification is deterrence. Punishment gives lesson to the offender by showing to others what would happen to them if they violate the law. Punishment is imposed to warn potential offenders that they cannot afford to do what the offender has done. So the fourth justification of punishment is incapacitation and protection. The public will be protected if the offender is being held in conditions where he cannot harm others, especially the public. Punishment is affected by placing offenders in prison so that society will be insured from further criminal depredations of criminals. So one of the justifications of punishment is to protect the public from the criminal behavior of the perpetrator. And one way to protect the public is to put the person into jails or to put the person into penal institutions. The last justification of punishment is the reformation or rehabilitation, which is the latest justification of punishment. Reformation or rehabilitation, as I've stated a while ago, mainly focuses on the changing of the behavior of a person from a law violator into a law-abiding citizen of the community. Now, if a person is found guilty beyond reasonable doubt by a competent court, maunay posible nga mga duration sa iya nga mga penalties. Okay? So, cadets, dapat memorize ninyo ni starting from arresto minor up to death penalty kung noon sa iya nga corresponding nga penalty. Okay? Because there is a big possibility that this topic will come out in the board examination. So, muna pinaka-basic in terms of the discussions under correction or under the institutional or non-institutional correction major area of criminology. So, magsugod ta sa arresto minor. So, dapat ma-memorize ni. Arresto minor, ang punishment or ang imprisonment is from 1 day to 30 days. Sunod sa arresto minor is arresto mayor. Arresto mayor is 1 month and 1 day to 6 months. Sunod sa arresto mayor is prison correctional, that is 6 months and 1 day to 6 years. Sunod sa prison correctional, we have prison mayor, 6 years and 1 day to 12 years. Then reclusion temporal, which is 12 years and 1 day to 20 years. And the last one is reclusion perpetua, which is life imprisonment. Kung may kag life imprisonment, ga-refer na sa reclusion perpetua. Ano sa man yung reclusion perpetua? Ang imprisonment niya is from 20 years and 1 day to 40 years imprisonment. Ang pinakataas, which is death penalty, we consider that one as capital punishment. But right now, in the Philippines, we do not have the death penalty, or the death penalty which was imposed a long time ago was already considered as officially abolished. So therefore, wala na tay punishment karon nga death. So naratagi ka diri sa arresto minor to reclusion perpetua. I am referring to the number of days or the number of months or years of imprisonment. So dapat may ma-memorize ni arresto minor up to reclusion perpetua. So if a person is already turned over to the correction pillar, he will now be considered as a prisoner. Okay? So unsa man ang prisoner? A person who is under the custody of lawful authority, a person who is detained or confined in jail, or a person committed to jail or prison by competent authority for the following reasons, like to serve the sentence, trial, or investigation. So if a person is awaiting trial and is put into custody, that person shall be considered as a prisoner. Or if the person is awaiting for investigation, okay, waiting for investigation from competent authorities, that person again shall be considered as a prisoner. Bahala pagwa pa siya na guilty, as long as na siya sa kustodiya by a competent authority, makonsider siya og prisoner. So prisoners are classified into 3. So these are the general classification. One is those persons who are being detained, ang tawag nila is detention prisoners. Those persons who are put into jail or put into prisons after final conviction, katunang ningon ang korte nga you are guilty beyond reasonable doubt, or those persons found guilty of the accusation, ang tawag nila is sentence prisoners. But if the person is detained or put into custody to protect the community against their harmful behavior, ang tawag ana is prisoners who are on safekeeping. Example ana is mentally deranged individuals or insane person nga giput into custody. On the other hand, we have also classification of sentenced prisoners. There are 4 classifications. One is, we will start from the bottom. One is municipal prisoner. Kinsa man ni? Mauni katong ang ilang punishment or ilang imprisonment is from 1 day to 6 months. Okay? From 1 day to 6 months. If the imprisonment is from 1 day to 3 years, ang tawag ana is city prisoners. If in case ang ilang imprisonment is from 6 months and 1 day to 3 years, ang ilang classification is provincial prisoner. On the other hand, take note, if the person will serve his sentence in a penal institution from 3 years and 1 day and above or to life imprisonment, basta 3 years and 1 day na at least, pataas, like say 4 years ba or 5 years, ang tawag niya is insular or national prisoners. If the person will be punished, like say for example, ang iyang punishment is 3 years and 6 months. Kung 3 years and 6 months, so sa tawag niya is insular or national prisoner. So as I have stated a while ago, under the positivist or Italian school, the persons who have criminal behaviors are considered as sick individuals who needs to be hospitalized. So the hospitalization entails a treatment program. So ang treatment program sa jails o sa prison, dili ni mao katong mga prescription of drugs, dili ni mao katong padoktoran ka, but rather these treatment programs would refer to 1. Prison education. 2. Work programs or livelihood programs. The third one is religious service in prison and others. So we will start with prison education. So prison education, those prisoners who do not have the elementary or secondary education, they can pursue their education inside the jail or inside the prison while serving sentence. So part of the Inmates Welfare and Development Program is also known as the Livelihood Program. So tudloan sila unsay mga maayo nga mga programa nga pangpanginabuhi. Like say for example, tudloan sila handicraft, tudloan sila paggama og whatever livelihood program nga pwede lang mabalaan para at least when they go out from jail, they will have now the skills in livelihood. We also have the religious services in prison. The purpose of the religious services in prison is to somehow change the attitudes of inmates by inculcating religious values or beliefs. Aside from the previously mentioned programs, we also have the recreational programs. So this is the program that is conducted during free time schedule. So sa mga recreational programs, mao ni katong basketball, watching TV, playing chess, and other recreational program inside jails or prison. Aside from that, we also have medical and health services. These are free. This includes mental and physical examination, diagnosis and treatment, immunization, sanitary inspections, participation in training. The last one is counseling and casework. So in counseling and casework, the prisoners will be advised as to their respective cases. They will also be advised about mental health. They will also be advised about morality or behavioral aspect of being a prisoner. So these are the modes and guidelines for the release of the prisoner. One is after the service of sentence. So kung humana og serve sa iyang sentence, let us say, mo serve siya 5 or 6 years, tapos na humana ang 6 years, automatic, kay na-serve naman, pwede na siya i-release. Or order of the court. Pwede po siya ma-release through parole, pardon, and amnesty. Now, who may authorize the release of the prisoner? So these are the following entities who are authorized for ordering the release. Number 1 is the Supreme Court in case of acquittal or grant of bail. The President may also authorize for the release in the cases of executive clemencies. When I say executive clemencies, this is an act of grace on the part of the Chief Executive or the President. So unsa man ni muna katong conditional pardon o absolute pardon. So kung ang President gigrant niya og absolute pardon or conditional pardon ang usa ka prisoner, bahalag wala pa siya kahuman og serve sa iyang sentence, pwede na siya nga ma-release. The Board of Pardon and Parole may also authorize for the release for parole cases. And the director, after the expiration of the sentence, may also release the prisoner. So when the person already served the sentence, or na-release ba siya because of executive clemencies or by parole or by amnesty, the person considered in the past as a prisoner, the prisoner will now go back to the fifth pillar, which is the community. So sa may nasa community, na diha ang private persons, private groups, and entities. So the private groups, the private persons, and private entities also have the responsibility in terms of crime prevention or crime suppression. Because without the help or without the aid of the last pillar, which is the community, the functions and the responsibilities of the law enforcement, the prosecution, the court, and the correction will never be a success. So kinahanglan nga importante nga ang prisoner will be accepted to the community with open arms. At the same time, dapat ang community will also help in fighting against criminality. So the following agencies have crucial role in terms of crime prevention. We have family, the cradle of human personality; the school, where education takes place; the church, which will teach religious or spiritual beliefs that will somehow prevent a person from the commission of a crime; the media, which can influence the behavior of a person; and other non-government organizations. So kaning mga institutions mao ni crucial sa crime prevention inside the community. So kung maayo ang pagdala sa family, maayo ang pagdala sa school, church, media, and other non-government organization, there is a big possibility that the crime rate in the community will decrease. At the same time, ang tao nga nagka-contact in this institution may have greater contribution also against crime suppression. In the community also, we have the barangay. Okay? Natay barangay sa community. So if in case there is a conflict between one member of the community to the other, na ginatawag og lupong tagapamayapa. Okay? Lupong tagapamayapa. This refers to the lupon. What is the lupon? The lupon consists of 10 to 20 members. Okay? 10 to 20 members. Kinsa may chairman ani? Composed of the punong barangay as the chairman of the lupon. The lupon shall be constituted every 3 years. So meaning, kahit tulura man katuig ang termino sa usa ka barangay kapitan, kung naay bago nga kapitan, pagkahuman sa election after 15 days, dapat mo constitute or magama siya og lupon nga consist of 10 to 20 members. So unsa man ni mga membro sa lupons? Unsa man ni mga membro sa lupon? These are persons residing in the same barangay not disqualified by the law, possessing integrity, impartiality, independence of mind, sense of fairness, and reputation of probity, can be appointed as a member of the lupon. So wala siya educational qualification. As long as the person is considered to meet the qualifications set by Republic Act 7160 or the Local Government Code of the Philippines, pwede siyang mamembro sa lupon. So kung naay conflict between one person to the other residing in the same barangay, pwedeng adto na sa lupong tagapamayapa. The secretary of the lupon is the barangay secretary. So kinsa man ni barangay secretary, muna katong gi-appoint sa barangay captain. So ang barangay secretary automatic lupon secretary pud siya. So if there is a conflict, there is what we call as the formulation of the pangkat tagapagkasundo. But usually the common practice right now is that if there is a dispute between two persons, ang unang nga mosettle ani is ang barangay kapitan. Okay? Tapos kung dili magkasinabot sa barangay kapitan, usa siya gi-turn over dito sa lupon. So kung ma-turn over na dito sa lupon, considering nga wala nagkasinabot, mag-form ag lupon o ginatawag og pangkat tagapagkasundo. Because it is very impractical if the 20 members will conglomerate to solve a common issue. Because 20 heads may create chaos. Okay? So kung dagan kayo, it would be chaotic. So ang 20 kabuk membro sa lupon, kung magdungan sila og attend on a dispute, ang mahitabo, it would be very chaotic. So para dili siya chaotic, what will happen is, among the 20 members mo create og ginatawag og conciliation panel or pangkat tagapagkasundo. Okay? Ang pangkat tagapagkasundo only consists of 3 members. Tulo lang kabuok. So meaning, out of 20 people who are members of the lupon, 3 members will be selected to form the conciliation panel. So kinsa may mo select sa conciliation panel? Republic Act 7160 states nga ang mo select ani is katong parties involved in the dispute. But if in case di sila magkasinabot in the selection of the conciliation panel, it will be in a draw lot system. So mag-lottery system, i-draw lots lang kung kinsa tong tulo nga mapili nga pangkat tagapagkasundo. So the pangkat tagapagkasundo or the conciliation panel will be the one to settle the dispute. The lupon members, while in the performance of their official duties or on the occasion thereof, shall be deemed as persons in authority as defined in the revised penal code. The lupon or pangkat members shall serve without compensation. But right now, in various barangays in the Philippines, even though the lupon members do not have a basic salary or monthly salary, most of them are receiving what we call as honorarium or a specific amount given to them every month. So the following are subject matter for amicable settlement and the exception thereto. The lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes except when one party is the government or any subdivision instrumentality thereof. So if in case the one party is a private citizen and that person will file a complaint relative to the performance of an employee of the government, dili pwede dito sa lupon isolve ang dispute, but rather the person will go directly to the court. Or naabay complaint against any agency of the government like the SWD, you have complaint with the DPWH or any employees of the city or municipality with regards to the performance of their duties, pwede ka mo diretso dito sa court. Where one party is a public officer or employee and the dispute relates to the performance of his official functions. So this is what I have stated a while ago, nga public officers or public employees are not subject for amicable settlement inside the lupon once the complaint is relative to the performance of their official functions. But if in case the complaint is not related to the performance of their duties, let us say for example, si Police Officer Juan de la Cruz ang iyahang kanding, nakakaon og kalamunggay diha sa inyuhang backyard. So, naamanay damages, dili man na ga-relate sa performance sa iyong duty. So, pwede kang moadto dito sa lupon. Pero if in case si PO1 ang iyang crime is relative to the performance of his duties, pwede kang makadiretso sa court. Next exception. Offense is punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos. So take note, cadets, that under Republic Act 7160 or the Local Government Code of the Philippines, ang jurisdiction sa lupon or jurisdiction sa katarungan pabarangay are only on offenses punishable not exceeding 1 year or not exceeding 5,000 pesos fine. Because if the crime exceeds from 1 year imprisonment, pwede na kang moderitso sa court. Dito say, for example, crimes against persons like murder and homicide, reclusion temporal man or reclusion perpetua. So, pwede kang moderitso sa court. Nga naman, kay ang crime exceeds 1 year imprisonment. But if the crime only involves like alarms and scandals, or while natulog ka, giitsahan ka o triangle o giitsahan imong balay og fireworks dayon nakuyawan ka, that's alarms and scandals, tapos wala man siya kabot og 1 year imprisonment, pwede siyang giagi dito sa lupon for amicable settlement. Next, offenses where there is no private offended party. This refers to victimless crimes. Unsa man ning walay private offended party? Let us say for example, gambling, so wala siya private offended party. Vandalism, wala siya private offended party. Prostitution, wala siya private offended party. So, tanan nga mga krimen nga wala private offended party, pwede nang dili giagi sa lupon. Where the dispute involves real properties located in different cities or municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. So, if the real property is located to a different municipality, for example, Municipality 1 and Municipality 2. Ang complainant is from Municipality 1, ang gi-complain is, or ang accused is from Municipality 2. Tapos, ang property, let's say for example, yuta, nga giawayan, nasa Municipality 3. So, in this case, wala man siya sa same municipality, pwede nga moderitso sa court. Pero naay exception. If in case, the two parties could submit their differences to an appropriate lupon, let us say magkasinabot sila nga adiri lang sa Municipality 1 nga lupon, isettle ang case, pwede. Pero kung di sila magkasinabot, automatically that will be subject for settlement in the court. Next, disputes involving parties who actually reside in barangays of different cities or municipalities, except where such barangay units adjoin each other and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. So, pwede again nga masettle on a particular lupon, bahala na gikan sa different municipalities. But if there is no agreement between the two as to the appropriate lupon for the venue of the settlement, din so be it, pwede madiretso sa dito sa higher authorities. So, if in case a person will file a complaint or will go to the police station to put into record that he was being punched by a person and he suffered slight physical injury, ang responsibility sa police officer is to determine first whether that complaint or whether the case is subject for amicable settlement at the lupon. So, kung under jud siya sa lupon, kaya wala na-exceed sa 1 year imprisonment, and a fine not exceeding 5,000 pesos, ang police officer will have to advise the complainant to go back to the lupon. Okay? In the same manner, if the person will go directly to the court or to the prosecution pillar for the filing of the complaint, and the complaint involves a case which is subject for amicable settlement at the lupon, it is the responsibility of the authorities to inform or to advise the complainant to go back again to the barangay or to the lupon to settle the case, because such case is under the jurisdiction of the lupon. But if ni exceed siya 1 year imprisonment or a fine exceeding 5,000 pesos, then that complaint can be given due process by the law enforcement, prosecution, and the court pillar. So, in the form of settlement, all amicable settlements shall be in writing, in a language or dialect known to the parties, signed by them and attested to by the lopon chairman or the pangkat chairman, as the case may be. When the parties to the dispute do not use the same language or dialect, the settlement shall be in writing in the language known to them. So, it is very important to note nga all settlements in the barangay or inside the lopon should be put into writing, and the manner or the language that should be used is the language that is known to the two parties, both the accused and the complainant. So as I have said a while ago, if the case is subject for amicable settlement at the lopon, there shall be no complaint, petition, action which should be instituted in the court unless nga wala jud nagkasinabot. So kung wala nagkasinabot sa lopon kay ang case or ang complainant dili mosugot or dili makigsettle, ang mahitabo is the lopon will issue a certificate of non-settlement. So ang certificate of non-settlement pwede na nimong magamit para ang imong kaso imong gi-pursue dito sa korte. So same process lang gyapon, moadto ka sa prosecution pillar, i-attach nimo tong certificate of non-conciliation to prove nga gikan na mo sa lupon kung ganahan kang i-pursue ang imong kaso. So again, adto na po na dito sa prosecution office lang taon kung nabay probable cause to hold the accused for trial. All proceedings for settlement shall be public and informal, provided however that the lupon chairman or the pangkat chairman, as the case may be, may motu proprio or upon request of a party exclude the public from the proceedings in the interest of privacy, decency, or public morals. So pwede nga in private siya kung mo request ang duha ka parties, or if the case or if the complaint or the dispute involves a minor, take note kadets, automatic ang tanan nga hearing diya sa barangay should be in private. Unsa man ning mga minors, I'm referring to those persons aging 18 years old below or below 18. So if the dispute involves a minor like 17 years old or below, it is not legal or it is not allowed under the law that the settlement should be in public. Because what is required under the Republic Act 7160 or the Local Government Code, the settlement should be in private basta ga-involve of minor. Lastly, the parties may at any stage of the proceedings agree on writing that they shall abide by the arbitration award of the lopon chairman or the pangkat. So if during the proceedings the complainant and the accused came up into agreement, so pwede nga i-stop na ang proceeding. Pwede na nga magama og arbitration award or unsay kasabutan. When we say award, this refers to the settlement or the agreement between the parties, between the complainant and the accused. So kung magkasinabot sa tunga-tunga sa proceedings, automatic pwede na nga magama og award or agreement. The award shall be written in the language or dialect known to them. So kung magkasinabot, automatic the award or the agreement will be put into writing. Okay? So that's the job of the lopon or the pangkat, tagapagkasundo in settling the dispute involving personalities in the same barangay. So take note again, dili pwede nga mudiretso ta sa korte. So what we have to put in mind is the number of years of imprisonment of a particular crime. So if a crime is within the jurisdiction of the lopon, under the law, it is not allowed to be instituted for action in the court unless there is an appearance inside the lopon. So kung wala nagkasinabot, the lopon issue the certificate of non-conciliation, that's the time that the person can pursue his complaint to the prosecution, to the court pillar of the criminal justice system.